This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of these videos. Today I'd like to talk about the crime fraud exception as it relates to litigation, especially litigation dealing with insurance issues. A waiver of the attorney-client privilege may result when an insurer is sued for bad faith and/or fraud. For example, California Evidence Code Section 956 provides, quote, "There is no privilege under this article if the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit a crime or a fraud." Close quote. Even without a statute, the license to practice law is not a license to commit a crime. One federal court ruled that a bad faith claim not involving fraud is insufficient to trigger the exception. In Freedom Trust, a case filed in the Central District of California in 1999 held that the insured who had argued that the privilege had been waived because the insurer denied coverage in bad faith. The court recognized that the attorney does not have to be aware of the fraud for the fraud crime exception to apply, and that the fraud exception includes civil fraud, so that the court noted a split in authority nationally as to whether a bad faith claim triggers the crime fraud exception. The court concluded that an allegation of a bad faith denial of insurance coverage was not sufficient to trigger the exception. It said, quote, "Bad faith denial of insurance coverage means simply that the insurer breached an implied contractual agreement to act faithfully to an agreed common purpose consistent with the reasonably justified expectations of the other party. This need not implicate false or misleading statements by the insurer. For example, an insurer may act in bad faith if it simply denies coverage without any explanation. The gravamen of fraud, however, is falsity. Thus, bad faith denial of insurance coverage is not inherently similar to fraud." Close quote. The decision was not meant to imply that an insurer cannot engage in activities that implicate both bad faith denial of coverage and fraud. Rather, it means that simple bad faith is not per se within the crime fraud exception. In many circumstances, an insurer's bad faith involves fraud or allegations of fraud. Conduct that constitutes a breach of the implied covenant of good faith and fair dealing is often alleged to be fraudulent conduct. California courts have noted that bad faith conduct involving deceit has often been regarded as fraudulent. If a carrier denied coverage for a claim that it knows is covered, it may have engaged in fraud, and the exception may apply. Under both federal and Connecticut law, for example, the party seeking to defeat the attorney-client privilege through the crime fraud exception bears the burden of showing there is probable cause to believe that, first, a fraud or crime has been committed, and second, the communication in question was intended to further the fraud or crime. The crime fraud exception applies only where there is probable cause to believe that the particular communication with counsel or attorney work product was intended in some way to facilitate or to conceal the criminal activity. The crime fraud exception to the attorney-client privilege, therefore, is a limited one, and the burden of proof is on the party seeking to pierce the privilege. The exception applies only after a determination by the trial court that there is probable cause to believe that a crime or fraud has been attempted or committed, and that the communication was in furtherance of that crime or fraud. The crime fraud exception to the attorney-client privilege cannot be successfully invoked merely upon a showing that the client communicated with counsel while the client was engaged in criminal activity. A client who used his attorney's assistance to perpetuate a crime or fraud may not assert the work product privilege as to documents generated in furtherance of his crime. The attorney who does not knowingly participate in the client's crime or fraud may assert the work product privilege as to his opinion work product, because the work product privilege is really not a privilege but a protection that is held only by the lawyer and not by the client, while the attorney-client privilege is held solely by the client. Where the client was the subject of a grand jury investigation to determine if he had received improper payments, the client retained an attorney to assist him in responding to the investigation. The client provided his attorney with a false story to explain how he received money improperly. Subsequently, in November of 2005, the government sought to obtain both testimony and documents from the attorney and the attorney's law firm. The law firm responded with a privilege log identifying 1,604 documents it claimed were protected by attorney-client or work product privileges or protections. The attorney refused to answer the grand jury's questions on the basis of attorney-client privilege. In June 2006, the jury indicted the client and another party. The court concluded that attorney-client communications and attorney work product are privileged and are ordinarily not discoverable, even to a grand jury. The court explained, however, that neither of these privileges is absolute, and that the crime fraud exception provides that the attorney-client privilege will not protect communications where the client is seeking legal advice in furtherance of a fraud or crime. The court stated that while ordinary work product is usually discoverable upon a showing of substantial need and the inability to obtain the same without undue hardship, opinion work product enjoys a nearly absolute immunity and can be discovered only in very rare and extraordinary circumstances. This is In re Murphy, an Eighth Circuit decision from 1977, and In re Grand Jury Proceedings, a 1989 decision of the Ninth Circuit. In a case where the government argued that therapists' records are not privileged because they were not created with any expectation of privacy, that the privilege was waived by asking the Veterans Administration to review records as part of his benefit application, and that the records were created as part of his plan to defraud the Veterans Administration and thus fell under the crime fraud exception. The district court agreed and ruled that the crime fraud exception defeated any claim of privilege for the person's statements to his therapist. This was United States versus Bowline, a 10th Circuit decision dated in 2019. The work product protection, often misconstrued as a privilege, is not designed to protect the client. Rather, it is an attorney's independent assertion of his work product protection to keep his or her work inviolate and not available to an opponent. It stands on a very different footing because the attorney's protection is based on the attorney's interest in protecting his opinions and thought processes from disclosure. This is a protection that benefits all of the attorney's clients because it accords the attorney a measure of privacy within which he can candidly compose his thoughts. To his work product, the fraud exception does not apply. Consider Miller v. National American Life Insurance Company, a 1976 decision of the California Court of Appeal, where the insured sued an insurance carrier for breaching its contract and for fraud in inducing the insured to purchase the policy. The insured argued that the policy expressly obligated the carrier to pay his monthly mortgage payments in the event that he became totally disabled. The carrier argued that because these representations were contained only in the insurance policy, they were insufficient as a matter of law to support a fraud cause of action. The court disagreed. Insurers must be careful when asserting the advice of counsel and ascertain that the following is true. 1. The advice given was fair and reasonable. 2. The insurer's employees reasonably relied on the advice in reaching the decision to deny the claim. 3. The attorney giving the advice can testify before a trier of fact in a reasonable, intelligent, and believable fashion to establish that the advice given was sound, and 4. That the advice establishes a genuine dispute between the insurer and the insured. Such advice, of course, becomes an absolute defense to the so-called tort of bad faith and will limit the insured to a recovery of contract damages only. And so the protections provided to attorneys by the attorney work product protection and the protection provided to clients by the attorney-client privilege are very important to every insurance claims investigation. This video was adapted from my book, Zalma on Insurance Claims, Part 106, Second Edition, the 6th volume of my 10-volume work, Zalma on Insurance Claims, and is available from Amazon.com as both a Kindle book and as a paperback. It can also be found in my website, Zalma.com, by clicking on the Insurance Claims Library for a more detailed description of the volume. If you found this video to be interesting or useful to you, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel and my Rumble channel and my blog so that you can learn about future blog posts and videos. Thank you for your attention.